Once you've chosen the structure for your business, there's a lot of things you need to consider before you actually deal with your first customer. I'll take you through a few different points today, but it's really important that you go and get independent legal advice specific to your entity. Dependent on your structure and your business, it's a good idea to get insurance so that you're not held personally liable. One of the most important considerations is to work out what intellectual property, or IP, your business has. The first question people often ask themselves is, can I patent my idea? Patenting is a very expensive and time-consuming process, and it also only applies to new and inventive ideas. There are a lot of ways in which you can protect your IP without actually applying and paying for a patent. Firstly, when you're dealing with anyone else, make sure you have an NDA or a confidentiality agreement, as they're otherwise known. This will make sure that your company information is kept confidential and protected. You should also look into trademarking your name and logo. You can do this yourself through the IP Australia website, and it's a very simple and inexpensive process that I would recommend to most businesses. Also make sure you can have a corresponding domain name. A big advantage to your business is speed to market. First in often gets the sales. So try not to waste too much time on complex registration processes and just go in and start your business. It's important to make sure that the company and not individuals own all the IP. If any individuals own IP outside of the company, these can be assigned over to the company with a simple IP assignment deed. If you're dealing with investors, they'll really want to know that the company owns all the IP that you're trying to sell them. As opposed to trademarks and business names, copyright is an automatic right. There's no need for you to register anything. If you're creating photos, videos, writing pieces, these are automatically yours and you own it due to Australia's copyright laws. For startups, another big issue to consider is the suite of startup contracts that you'll need. If you're dealing with customers, you might need customer terms and conditions. Alternatively, if you're a service provider, you'll need a service provider agreement, which sets out the services you provide and the amount of money you'll be receiving for those services. In any contract, one of the key clauses that lawyers look at and that you should also look at is the liability and indemnity clause. This sets out exactly what you'll be liable, responsible for, and also what you need to indemnify the other parties for. In other words, pay the money back. You need to make sure that your liability is limited and that you're not indemnifying them for things you aren't actually responsible for. Make sure there's a cap on your liability in your contract, otherwise you could potentially be sued for millions. And for example, in a service provider agreement, I often suggest that you cap your liability at the amount you've charged for your services. If you're a software company, it's really important to check that you own all the code that you've developed. So make sure you've written your own code, or it's open source, and that you're allowed to use it. Every agreement will expect you to say, we've developed this ourselves, or we have the legal right to use it. The interests of startups and investors aren't always aligned. If someone comes to you with real money and wants to invest in your business, I suggest you get professional legal advice to make sure you don't fall into any traps. If you're a UNSW student or recent alumni, we run an Entrepreneur Legal Centre which offers free legal advice for startups. So come along and see us. Next time, we'll be looking at different ways you can finance your project to help it grow. Please leave your thoughts on our series below.